This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
Now, please allow me to introduce our next speakers, Glenn Barger, Mayra Fornos, and Pat Kelly, for another 2 hours of ethics titled Ethics, Recent Developments, and Hot Topics in 2023 and Beyond. So first, I have Glenn Barger, who was a practicing attorney for almost 30 years and handled the same types of cases he now mediates throughout California. He now serves as a full-time mediator at ADR Services, Inc. As a mediator, Glenn has helped resolve a wide variety of matters, including automobile and premises liability, bodily matters, sexual abuse, TBI claims, and wrongful death actions, business and contract disputes, including insurance and indemnity issues, construction, including delay claims and defects, commercial and residential real estate, landlord-tenant and habitability issues, and professional liability matters. He is also well-versed in governmental and public entity issues, including inverse condemnation and property damage claims. He is an active member of the legal community and is involved in several legal and professional organizations in Los Angeles. He is a past president of the Association of Southern California Defense Counsel and served on the LACPA Litigation Executive Committee. Mr. Barger is also an avid proponent of promoting civility and ethics in the courtroom and is highly respected by attorneys on both sides of the bar. Mr. Barger has extensive trial, arbitration, and mediation experience, which he draws upon to assist parties in designing pragmatic and creative resolutions. Next, we have Mayra Fornos, who is an accomplished litigator with 29 years of experience handling a wide range of civil matters with extensive experience in the fields of catastrophic personal injury, including spinal cord injuries and vehicular accidents, premises liability, products liability, elder abuse, wrongful death, medical malpractice, employment discrimination, ADA, and family law. Ms. Fornos has received numerous awards and accolades for her advocacy. She has been listed in Best Lawyers in America since 2011, Super Lawyers since 2012, and was named one of the top 50 women attorneys in Southern California. She is a recipient of the President's Award from the Consumer Attorneys Association Los Angeles and was a finalist for Advocate of the Year by the Women's Caucus of the Consumer Attorneys of California. In addition, she is a recipient of the Los Angeles Business Journal's Women Making a Difference Award and was listed in Los Angeles Magazine as one of the Los Angeles women leaders in the law. Mayra is a full-time neutral and available for your mediation needs. And lastly, Patrick Kelly joins us today to discuss the amended rules of professional conduct. It goes without saying that we live in difficult times with challenges and problems around every turn. Among other things, coronavirus issues affect every aspect of our society, creating constantly evolving legal and ethical issues for all attorneys in California. To add to these challenges, a revised ethical fabric was created by the significant changes in the California rules of professional conduct in November of 2018. But as Duke Ellington once said, a problem is a chance for you to do your best. Mr. Kelly is a former president of the California State Bar, the Los Angeles County Bar Association, the Professional Liability Underwriting Society, and numerous other professional organizations. For over 35 years, he was a member of the executive committee and was the Western Region Managing Partner and Director of the litigation for the international law firm of Wilson, Elser, Moskowitz, Edelman, and Dicker. He was also a voting member of the California Judicial Council, which oversees our state courts and has been honored by membership in the American Board of Trial Advocates, the International Academy of Trial Lawyers, and the Federation of Defense and Corporate Counsel. He is an original co-author of Insurance Litigation, the Rudder Group California Practice Guide, and has received numerous awards and offices for his leadership in the legal and professional community. He is currently a mediator and arbitrator with ADR Services, Inc. Glenn, Mayra, and Pat, take it away.
Thanks, Hayward.
Thank you, Hayward. All right, so thank you, Hayward. And it's always absolutely great to work with you. And I am delighted to be presenting today and to share this platform with the highly regarded Glenn Barger and the legendary Pat Kelly, who are both my mediator colleagues at ADR Services, Inc. And I would like to take just a brief moment to thank Lucy Barron, the gracious Lucy Barron and Joanna Barron, and everyone at ADR Services for putting together this comprehensive and informative webinar that we believe will provide indispensable information on the topic of ethics for all of you, hopefully, and which, as you know, is a hot and newsworthy area in our profession at the moment. And as you will see, there's been significant changes that have been implemented in the rules and codes governing this important topic. And as Hayward pointed out and indicated, I will be covering two topics, and they are, the first one is ethical issues involving case sharing and fee splitting. And my second topic will cover the ethical requirements and rules that apply at mediations and at mandatory settlement conferences. And within this topic, I will be addressing mediation settlement discussion privileges, the duty of candor, and the essentials for binding the parties to a settlement. Slide forward, please. So let's begin with our first topic, case sharing and fee division between lawyers and the applicable rules governing this area. In today's legal climate, more and more lawyers and firms, from both sides of the table, are finding it extremely beneficial to bring in another lawyer or firm to help work on a case. And many times the reasons may include bringing in or associating a particular lawyer or firm because they may possess notable expertise or superior knowledge in a specific area of law. Or maybe they can help with the responsibilities involved with the representation or with the administrative obligations, or perhaps even to try your case. And this is normally a good thing. Prior to being recruited by ADR Services to become a mediator, I had my own trial firm for 29 years, and there were many times that I brought in outside counsel, sometimes the biggest guns out there, to assist me with multi-level complex cases. And likewise, there were also many times when other lawyers or firms brought me in to help out with their cases. So there are enormous benefits for the opportunity to share cases with other lawyers or firms. All right, next slide, slide 5. So a little history here. Attorney rules are officially entitled, as you know, California Rules of Professional Conduct. And like it was mentioned earlier, in May 2018, the California Supreme Court approved 69 new and revised rules, which became effective in November 2018. And Pat Kelly's really going to get into this later on. But many of these rules affect case sharing and fee division between lawyers. Among the rules is professional rules of California Rules of Professional Conduct 1.51. And this new rule replaced former Rule 2200 and contains two material changes that allow California attorneys to split fees with other lawyers who are not in the same law firm. Slide 6, please. Okay, so let's take a look at this new rule. First, the fee sharing agreement between the lawyers must be in writing. And second, the client must consent to the division of the fees after full disclosure is given to the client by the lawyers either, and this is what's important, the client must consent after full disclosure either at the time the lawyers enter into the agreement to divide the fee or as soon thereafter as reasonably practicable. Under the former Rule 2200, there was actually no requirement whatsoever for the client's express consent. And the client could actually consent, if he even did so, at any time up to the time when the fees were actually divided. Unfortunately, even though the new rules have been in effect for about four and a half years, a significant number of lawyers are still under the impression that they have until the fees are divided to obtain their client's consent. And well, this is just simply not so now. And like I said, many lawyers are still not aware of this rule, this very important rule, if they in fact share fees with others. And so, according to the Commission for the Revision of the Rules of Professional Conduct, these changes were made because an underlying reason for the rules regulating fee divisions among lawyers, and it was actually to assure that the client's representation would not be adversely affected. So enclosed in the material that I have provided, there are the relevant portions of the code sections and rules, as well as an executive summary, a very important executive summary of Rule 1.5.1, which provides a detailed explanation and reasoning behind the modification of the rule. I've also included a sample of a standalone document of a fee splitting agreement consent form, which, by the way, the verbiage can be inserted into the retainer agreement that you have with your client. I hope those help. Now, in addition to the requirements of having fee sharing agreements in writing and of having the client expressly consent to the fee division, which, remember, and I'm going to be like drilling this, must be obtained at the time the agreement is entered or as soon as reasonably practicable. Slide 7, please. The attorneys must also disclose to the client the identity of the attorneys or law firms that are the parties to the fee division, and also the actual terms of the division. For instance, if there's a 50-50 split, or if there's a 75-25 split, or if there's joint responsibility for the representation of the case, or for sharing of the costs, and so on. Slide 8, please. In addition, it's important to note that the total fee charged to the client by all attorneys working on the case cannot be increased solely by reason of the agreement to divide fees. Otherwise, the increased fee may be deemed unconscionable and thus unenforceable. So keep this in mind. There are two fairly recent cases on point that I would like to review with you at this time that can show you how important this rule is. The first case is the case of Edelson PC versus Girardi case, which was filed in the U.S. District Court for the Northern District of Illinois. And there's a very important reason I picked this case, even though it was filed in Illinois. The firm Girardi case raised the issue in this case of lack of client consent in its motion for summary judgment with respect to the fees. The clients in the underlying Lion Air crash cases had not consented to the fee sharing agreements between the two firms. The Edelson firm then sought thereafter and obtained the client's written consents in 2021, 2 years later, and after the case had actually settled. The two firms had previously entered into a fee sharing agreement in I think 2019. But the clients were never copied with the fee sharing agreement, nor had consented to the fee sharing agreement, as they were never provided with any information regarding a fee splitting agreement between the firms. Well, the court here ultimately applied forum law, and in this case was the Illinois Rules of Professional Conduct, which completely obviated California's new rule regarding the required timing for obtaining the client's consent to the fee division, and found the fee splitting division to be enforceable. Okay, this is Illinois, remember. Note, however, had California law been applied, the fee sharing agreement most likely would not have been enforceable, as the timing requirement to obtain the client's consent under the new rules were not met. And according to another recent case, the court found that so-called acknowledgement alone does not equal consent. And in that case, very sadly, the referring attorney sued to enforce a referral fee agreement after the lawyers that had entered into the referral agreement with him failed to pay the referral fee. The jury later found that the referring attorney was entitled to recover for breach of contract for the referral fee, and also under a quantum merit theory. In this case, the case was appealed with argument that the referring attorney could not recover for breach of contract and recover fees because the client did not provide a written consent to the fee division arrangement as required under the former rule of professional conduct, Rule 2200. The court went on to hold that even though the client had later signed an acknowledgement that the client had received a letter regarding the division of fees between the lawyers, that he understood the content of the letter, which explained the agreement between the lawyers wherein the referring attorney would be paid 25% referral fee, and that the total attorney fees would not be increased or come out of his share of the settlement proceeds. And also the client testified that his acknowledgement expressed in the agreement that the referral fee could be paid to the referring attorney. On appeal, however, despite the signed acknowledgement and the client's testimony, here he had a signed acknowledgement and he also testified. In spite of that, the appeals court concluded that the letter did not comply with the consent requirements of former Rule 2200 because it did not reflect the client's written consent. The court further found that the testimony of the client that he regarded the acknowledgement as consent did not remedy the technical failure of meeting the requirements of the former Rule 2200. The appellate court held that written consent actually requires written words expressing agreement or acquiescence, not just receipt or understanding, and thereby held that the referral fee agreement was unenforceable as against public policy. And ladies and gentlemen, this is an ouchie, so be mindful of this very important rule. However, on a side note, where a referral fee is unenforceable, the referring attorney still has the option of obtaining recovery of the reasonable value of the services that he rendered pursuant to a quantum merit theory. The statute of limitations for recovery in such cases is only 2 years. So, and that's pursuant to Code of Civil Procedure, Section 339. And but in this case, unfortunately, the statute of limitations had run, and the court held that the applicable statute of limitations barred the referring attorney's quantum merit claim. So this works for both sides. It doesn't matter what side you're on. If you're going to hire an outside counsel, make sure you get everything in writing and that is consented in a timely fashion. This case I just discussed was very unfortunate for the referring attorney, but extremely valuable information for all of us to have. So as you can see, complying with the rules of professional conduct is fundamental to all fee-sharing relationships. Okay, and so remember that here, fee sharing amongst lawyers that are not in the same law firms, no matter what role they play in the case, is permitted in California, provided that these ethical rules are followed. And because it's such an important rule, I want to recap what I just went over with you, and just remember that the lawyers must have obtained a timely written consent from the client, and that they themselves have secured a written agreement on the fee divisions, and that the terms must be disclosed and consented to by the client, and include the following: that the attorneys must disclose that a division of fees will be made in the client's case, and they must disclose the identity of the lawyers or law firms that are parties to the division, and must disclose the terms of the division. And remember, it's important that the ethical requirement that the total fee charged by all attorneys cannot be increased by the fee splitting agreement. And failure to ensure compliance here with these regulations, again, can result in the total fee charge being found unpunishable and unenforceable. All right. Let's look now at slide 9. Although most cases, although most states follow ABA Rule Model 1.5E, which requires fee divisions to be in proportion to the services performed by each attorney on the case, and or assume joint responsibility for the representation. This is not the case in California, as California remains one of the few states, very few states, that permits pure referral fee agreements without requiring the attorney either to be paid in proportion to the actual work performed or accept joint responsibility for the representation as required by ABA Rule 1.5E subsection 1. So if you're a California attorney and you are entering into a fee sharing agreement with an out-of-state attorney or fee, be mindful that most jurisdictions follow ABA Rule 1.5E, again, wherein the referring attorney is compensated only in proportion to the work they actually do on the case, or based on joint responsibility that they share on the matter. California does not have these requirements, as California acknowledges pure referral fees, and so which is a very good thing for attorneys that refer fees. Okay, so I have a couple of things I want to bring up in this area, and that is, as a reminder, that California ethical rules require that lawyers who do not have professional liability must disclose that they do not have liability insurance, because here's the catch, because the absence of that disclosure would make the fee sharing agreement unenforceable. And there is a case on point here, Hans versus Superstore Industry. It's a 2020 case that you should maybe look at. And also you can refer to California Rules of Professional Conduct 1.4.2. And one last thing that Glenn will be expanding on, that while right now there are overtures by the California Bar to allow paraprofessionals to practice law in certain areas, a fee split agreement between a licensed attorney and a non-attorney is illegal at this time, under California Rules of Professional Conduct, Rule 5.4, subsection A. And finally, also take heed that any fee sharing or referral agreement among lawyers that of different firms that do not comply with Rule 1.5.1 is void and unenforceable on public policy grounds. So, alrighty, we are done with my first topic, but before I move on to my second topic, I would like to ask my co-presenters, Glenn and Pat, if they have any comments or words of wisdom they would like to share with us. Gentlemen?
I would like to comment on it, frankly, Mayra, and thank you. That was a very, very good discussion. I think the most important thing to walk away from this topic is what you emphasized, which is, number one, to make sure that you've conferred with the client on everything that you want to do in this area. And number two, make sure that the disclosures and discussions you've had is confirmed in writing and signed off by the client. I think those are the two most important tips arising from this entire subject matter.
That's right. That's absolutely right.
And I would agree with that, especially the in writing part, but also make sure the client actually understands what the fee splitting agreement is. As I've seen it come up in mediations where parties, typically the plaintiff, are confused and want to know if they're going to be having to pay additional fees because there's now another firm involved in the case. And then I also would say that I've seen cases where attorneys, you'll be shocked to know, law firms break up or attorneys split off from law firms and take cases with them. And that creates a whole host of issues, which you could get into detail on. But typically the amount of the fees may not even be known until after the case is over, especially if there's a referral attorney involved in the case, and it can lead to issues after the fact. And when they come up, you again really need to keep the client informed and make sure they understand what's going on.
Glenn and Pat, you hit it on the nose here, and it's that the clients need to understand. But what's really important actually for the attorneys is that they get this written consent timely, because if it's not done at the time that the fee agreement was entered between the lawyers, or as soon as possible, reasonably practical, that fee arrangement may be voided. It may not be enforceable. So make sure that you do this, that you get the client consent timely. Okay. So I suppose we go on right now to my second topic, and slide 10, please. All right. So my second topic is ethical requirements and rules at mediation and at mandatory settlement conferences for both attorneys and their mediators. And wherein I will be tackling the issues involving mediation settlement discussion privileges, the duty of candor, and the essentials for binding the parties to a settlement. Slide 11. So let's first discuss confidentiality and privileges applicable to settlement discussions. Many lawyers, I can't stress this enough, are unaware that there's an important difference with a statutory distinction between mediations and mandatory settlement conferences. And that is the issue of confidentiality, which is set out in several sections of the evidence code. The distinction here can generate immense confusion and can be a trap for the unknowing. Slide 12. Slide 12. Okay. So in trial court proceedings, the main rule is contained in Evidence Code Section 1119, as we all know, which establishes broad confidentiality for mediations, prohibiting disclosure of any information obtained in the course of mediation. And section 19, its language says it bars disclosing anything said or any admission made for the purpose of, in the scope of, or pursuant to a mediation or a mediation consultation. Also, Evidence Code section 1121 prohibits mediators from communicating with the court absent consent of the parties. And pursuant to Evidence Code 1152, the parties' demands and offers made during mediations cannot be introduced at trial to prove liability. Slide 13. In contrast, however, mandatory settlement communications are not confidential. The Evidence Code expressly excludes mandatory conferences from the mediation confidentiality provisions of 117 subsection B2. So as you can see, there's a significant difference, an important difference here for all counsel to be aware of. But as we all know, with most rules and regulations, there are several exceptions that allow admissibility and discoverability of mediation confidentiality. And these exceptions are listed in various sections of the code, which I will not be addressing due to time constraints, but I encourage all of you to take a look at them. And they deal with, for instance, conduct exhibiting during mediation or communications during criminal proceedings, and with evidence that would be admissible or subject to discovery outside of mediation. So take a look at those. And also on a side note, I know that court order ADR programs usually follow California rules of court or the local rules. And that in federal court proceedings, confidentiality is enforced through the federal rules of evidence, Rule 408. All right, so let's take a look now at Section 1121. The new section that was added to the Evidence Code by Senate Bill 954, and which became effective in January 2019. And under 1129, California lawyers are required to provide written disclosures to their clients explaining confidentiality and confidentiality restrictions in mediation. And by the way, ADR takes care of all this, providing the form for the lawyers to fill out and the clients to sign. In addition, the lawyer must obtain a written acknowledgement from the client that they understand the disclosures. And this is before the client agrees to or participates in the mediation. Slide, excuse me, that was slide 14. So, now please go to slide 15. These disclosures and written acknowledgement from the client are now mandatory in all matters other than class actions and representative actions. And the code even sets out the preferred language for the disclosure in a 12-point font of a single page of a standalone document, which must be signed and dated by the client and by the attorney. Senate Bill 954 sought to resolve the lack of client awareness of confidentiality, but also to inform the clients of the potential consequences as demonstrated by the 2011 Supreme Court case, Castle versus Superior Court case. And real quickly, in Castle, the Supreme Court held that private communications between an attorney and their client related to mediation must remain confidential, even in a professional negligence setting. Wherein the client here contended that the attorneys obtained his consent to the settlement through bad advice, deception, and coercion. Here, the legislation's intent was to prioritize and protect the candor necessary for a successful mediation at the expense of and above other policy considerations, including the client's capability to prevail in a malpractice action against the lawyer. So now, sorry, I went through that so quickly. Let's go to slide 16. And on issue of candor towards the courts, the California State Bar issued another rule, and that is Rule 3.3, candor towards the tribunal. And this rule prohibits knowingly making a false statement of fact or law to the tribunal. And Rule 3.3 goes farther than former Rule 5200, and that it actually requires the attorney to correct a false statement of material fact or law that the lawyer previously made to the tribunal. And by the way, the tribunal is defined broadly by here and includes the court, an arbitrator, an administrative law judge, a special master, or any other person whom the court refers a matter when a decision or recommendation of the person would bind the parties if the court approved it. The rule mandates that if a lawyer, the lawyer's client, or a witness the lawyer called has offered material evidence that the lawyer comes to know later or knew, but comes to know later that is false, the rule requires that the lawyer, quote, shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. And the only exception is that if the information the lawyer has learned is confidential client information protected by Business and Profession Code section 6068, subsection E, 1, and California State Bar Rule 1.6. And by the way, the obligation to take the reasonable remedial measures lasts until the conclusion of the proceeding and until a final judgment has been affirmed on appeal or the time for review has passed. Slide 17. Okay, and now the duty of candor during a mediation or settlement conference falls within the scope of another rule, and that's Rule 4.1, which again prohibits against knowingly making false material statements to a third party when representing a client, and that third party includes a mediator and a settlement officer, amongst others. So in the end, my point here is that we all want our words, our actions, our decisions to be fair and equitable. And we have all taken an oath that as an officer of the court, we strive to conduct ourselves with dignity, courtesy, and integrity, which includes the duty of candor. And our obligations go beyond that of zealous advocate on behalf of our clients. And we must never forget this. Okay. Moving forward, slide 18. So now we've come to the final area that I will be covering, and that is new requirements in binding the parties to settlement agreements. And effective January 2021, the amended version of Civil Procedure Section 664.6 establishes a new requirement for binding the parties after negotiations or mediations, including by permitting lawyers to execute and sign settlement agreements and settlement documents, and to make requests for the court to retain jurisdiction to enforce settlements on behalf of their clients. And of course, this applies with limited exceptions. But lawyers are now allowed to sign settlement documents, provided they have the express written authority, once again, the express written authority of their client. And this is a change that was intended to streamline the settlement process and an expedient way to enforce settlement. Beware that if the rule is not followed, it may subject the lawyer to professional discipline. So make sure you obtain your client's express written consent before signing any settlement documents. So I have reached the end of my presentation, and I truly want to thank you once again for joining us here. And if you have any questions or would like to reach me, you can do so by contacting ADR Services Inc. or by emailing me directly, and I'll be happy to answer any questions you may have. And now, if my co-presenters, Pat and Glenn, have any comments or once again want to share their sage wisdom, I'd like to invite them to chime in.
Well, a couple of things I wanted to, sorry, Pat, go ahead.
Go ahead, my friend.
A couple of things I wanted to jump in on is because it's been coming up more and more, I'd say almost once a week these days. In terms of the release agreement, and Mayra spoke about the mediation privilege, where counsel are asking me as the mediator to draft the settlement agreement. And obviously ADR has the short form agreement, but beyond being just a scrivener out there, I don't believe a mediator can actually draft a settlement agreement because that gets into practicing law.
Right.
And to the extent there is an issue that comes up after the fact, the mediation privilege is going to be out there in terms of what was said and discussed. And also the mediator doesn't want to find themselves in the position of being a witness where one side is asking you to say something. So keep that in mind. The attorneys need to draft the agreement, and then me as the mediator, Pat or Mayra, can get involved in helping you work out those terms, but really shouldn't draft it. And another sort of sub issue to all that, again, is this mediation privilege issue. And I say this tongue in cheek, but I always thought the benefit of going to private mediation was you could misrepresent all you want to the mediator as opposed to the court because of that mediation privilege. And in some ways it's true because a mediator can't go to the court and report misconduct. And even again, there's confidentiality and mediation privilege issues out there where have to be careful with it. So one thing I'd encourage all parties, especially, I'd say it comes up a lot in the pre-lit mediations where insurance is involved. Get the policy limits outside of the mediation process. Obviously, formal discovery hasn't begun in the pre-lit stage, but it's not going to do any good if you get that during mediation. You really need to ask for it outside of mediation so that you can confirm the policy limits if you're going to rely upon that to settle a case.
That's a very good point, Glenn.
I have a couple, Mayra. And one of them's going to key off of Glenn's, which is one of my points, which is the safety tip is to remember that the mediation privilege can act both as a sword as well as a shield. And I've had litigated matters in which a carrier, for example, would like to take the position that a good faith offer was made in mediation. The answer is that that's covered by the mediation privilege. However, there's an equal danger in the mandatory settlement conferences because I think most attorneys believe that under an MSC, you have the same protections that you do in a mediation. As you correctly pointed out, Mayra, you can't say it too often that those protections do not exist in a mandatory settlement conference. In fact, I'll go beyond that. I've had a case where, in fact, the disclosures and comments that are required in the case management seats in one of our counties with regard to teeing up a mediation or a mandatory settlement conference require disclosures. And all of those disclosures that are made in that documentation and the briefs that you file all are technically fair game in terms of evidence, and it can have a major impact when you're trying to, for example, deal with a potential bad faith situation with a carrier. And so the important rules to remember are the ones you named, which is one, don't count on any mediation privilege in a mandatory settlement conference.
Right. That is right.
And number two, don't believe that you're going to be able to introduce demands and offers in a mediation before in a normal mediation, not a mandatory settlement conference, because you can't, and it can become a very serious problem. One other final thing, a way to cap off the mediation and make sure the privilege doesn't apply is for counsel to send a communication to the mediator that the mediation is terminated before making offers and demands if you want them to have an evidentiary quality. So those are my safety tips.
That's great, Pat. And I really look forward for listening to you cover all the rules. I'm sure you're going to have a lot of wisdom there to share with us. So I want to thank you again for your time. I have a number of questions that were sent my way, and I will be responding to those after the session is over. So thank you for those questions, and I would be happy to help you. And again, you can contact me by calling or email me as well afterwards. Thank you.
Great. Well, thank you, Mayra. That was excellent. We wanted to at least briefly cover on the client trust account protection program. Mayra mentioned earlier that there's been a lot of high-profile attorneys in the news related to client trust fund issues. And I think many of you are following in my footsteps and getting in your MCLE requirements on the eve of the deadline for renewing your license this year. And when you do, you're going to see that there's a couple new questions as a result of this client trust account program that's out there. And we just wanted you to be prepared for it and understand it, as there's obviously a host of ethical issues involved in trust accounts. Next slide. So again, it's not a surprise. You've been following it in the news. There's been many high-profile lawyers that have been in the news for client trust account issues. And that led to the creation of a committee on the special discipline case audit in mid-2021. And actually, when the committee came out with its findings and recommendations, they actually specifically referred to Tom Girardi as probably being the most high-profile one. And they indicated that they looked at some of the closed discipline cases against him to try and come up with this program. The stated goal that they've said led to the creation of this is to proactively regulate client trust accounts and to help quickly identify attorneys with issues, including willful noncompliance, obviously for the protection of innocent parties out there. It has now gone into effect, effective December 1, 2022. So again, if you've renewed, you would have come across the process when you submitted the paperwork online. And the California Supreme Court has signed off on it. And it has real specific requirements, including the modification of California Rules of Professional Conduct 1.15. Next slide. So I don't think it needs to be said, but in many ways it does, because obviously there's many lawyers out there that are getting disbarred each year for issues with client trust funds. But to the extent an attorney holds on to money or property that is the client's, there is a fiduciary relationship there that's been created, and lawyers have statutory and ethical obligations to safeguard those funds for the clients. The funds must be kept separate from their personal and business account. Simply put, no commingling of funds, and that's probably one of the biggest issues you see with lawyers that ultimately get disbarred. You must set up either a single interest-bearing trust account for each individual client, or what's called a pooled interest lawyer trust account, IOLTA, where the interest is collected and then used to fund legal services programs. Again, this program is designed to better protect the public and better support attorneys in meeting all of their obligations. Next slide. Basically, all attorneys that are in good standing must comply with the new requirements, including registering any client trust accounts, including the IOLTA accounts, annually with the state bar now. And you need to complete an annual self-assessment. Again, when you're renewing your license, it's real simple if you don't have a trust account for whatever reason, or your firm doesn't have a trust account. But if you do have a trust account, then you need to answer yes and go through a number of questions. And there you need to certify with the state bar that you understand and you're following all the requirements and prohibitions pursuant to the modified rule 1.15. All of this can be done through your state bar profile. And this year, the deadline for reporting is the same deadline as paying your annual license fees, which is February 1st, 2023. But the state bar said they won't impose any penalties until April 2nd of 2023. So they've given a little bit of leeway there. Next slide. Also, and I guess I should note, I've heard of some issues with registering these accounts, including for out of state or out of country, out of US banks, and also issues for people who tried to register these before year end, because you need to give your year end balance of your trust accounts. Again, all of this is going to result in penalties for failure to comply, including an attorney will be enrolled as inactive if they don't comply with the requirements when they renew their license. Next slide. And next slide. The big part of this is the self-assessments, and some of the issues that we wanted to focus on, or I wanted to focus on, was anyone who has a trust account, again, even if you're part of a firm that has trust accounts, needs to answer yes to the question of whether you have a trust account. But the state bar has said that a subordinate lawyer who really has no involvement whatsoever in managing or maintaining client trust accounts can rely on their supervisory lawyer to confirm that the duties and obligations are being met by the firm. And the state bar has said on their website and some of the materials they've released that you are entitled to rely on those responses. They give an example of a lawyer working for a large firm who has absolutely no client contact. My thought on that is sufficiently vague that I think you need to err on the side of caution. And again, at least confirm that through your supervisory lawyers at the firm that all of the requirements are being met. Otherwise, you could find yourself with an issue down the road. Again, the objective of all this is self-assessment, is to promote awareness of the duties for both parties out there, but also for the attorneys themselves. And lastly, on this slide at least, that there are no exceptions. If you've got trust accounts for clients who are out of state or out of country, or holding property out of state or out of country, you still need to comply with the self-assessments and respond yes to the question when you're renewing your license. Next slide. The state bar does expect there to be future enhancements. This is the first year, including expanded public outreach and education, enhanced education for attorneys, and ultimately compliance reviews of selected attorneys by CPAs. I don't think it's been made clear as to how they would choose those attorneys and who they're going to review. And I think that may lead to a host of issues and controversy. But it is something that they've noted will be coming in the future. One thing that I think is interesting is there really isn't any discussion in there, though, or that's been put out in the program about what the state bar may do to monitor whether there actually is compliance, because obviously some of the issues that have come up in the last couple of years was put out there and was reported, but for whatever reason didn't lead anywhere. And I think that's one of the biggest issues that probably still needs to be addressed. Going to the next slide, please. Mayra, I believe, mentioned Rule 1.14 before, and there is a new comment now as a result of this modified rule. And client funds are specifically noted to be significant developments, which then must be promptly communicated to the client. So they've made it real clear that receipt of client funds must be promptly communicated to the client. Rule 1.15, or pursuant to Rule 1.15, you must notify your client within 14 days of receipt of the client funds or property. And ultimately, the funds must be dispersed within 45 days of the client interest in those funds becoming undisputed. Again, I think that's a potentially gray area, and frankly, anyone who's open to doing something like this and playing with client funds and client trust accounts, I think it's a potential gray area, including with regard to class actions and determining when, in fact, it becomes undisputed that the client is entitled to a set amount of funds. I think these things can be drawn out, and I think it's something the state bar is going to have to look at least in reading some of the commentary that's been out there over this new program. Even just making sure liens have been resolved can tie up the release of funds. And I know the goal is to try and avoid situations where money is taken. And so again, the commentators are saying that issue is going to have to be looked at. Another issue is, again, for the lawyers that are willing to do something like this and really put their livelihood and their license on the line for whatever reason, I think there's still going to need to be work to figure out when these issues are reported to the state bar, how are they investigated, how are they resolved, making sure there's fairness across the board in terms of all lawyers. And that's something I think the state bar is looking at, but it gets into some of the funding issues that are also been in the news for the state bar, including really what they claim to be a shortage of funds to administer some of these investigative policies of the state bar. So with that, any thoughts or comments on this new rule, Pat?
Yeah, I have a couple, and I'm going to go into this a little bit more detail. In fact, I was a victim of the circumstance because being a mediator, I don't have a client trust fund anymore. So I assumed, well, since I don't have one, I don't have to do anything. But I thought, well, maybe I should look at the rules and double check that. And quite frankly, a safety tip is even if you don't have a client trust fund or responsibility for it, you still have to fill out the correct answers to the questions on your profile, or you'll be in violation. You'll be one of those that as of April 2nd gets a nasty note or some other penalty. So everyone must deal with that section of their profile, whether you have a trust account or not. That's number one. Number two, looking at the duties of a subordinate lawyer really does create an issue with regard to many of the larger firms. As you, some of you know, I was the Western Regional Manager for an international firm for a long time, and I can just imagine the problems this might create. But don't forget that as a subordinate lawyer, that's one who's supervised, you must still exercise independent judgment to determine if there is an arguable question as to whether the supervisor's resolution is reasonable. That ethical rule applies to client trust funds. So you can't skate by just saying the supervisor did it and I'm fine. You have to exercise your independent judgment. So that would be my second on this. I'll go into that a little bit further in my segment of the lecture.
Thanks, Pat. Myra, did you want to offer a
Yeah,
couple
well,
comments?
just the thing that sticks in my brain is that I've spoken to some lawyers and they're like, what? We have to notify the client within 14 days? What? We have to disperse these funds within whatever, 45 days, I think you said. Just like overwhelmed. They just, that's not enough time. We still are working on, like you said, the liens. And so, but it's something to keep in mind because the bar is very serious about this and they are going to be looking into this issue. So notify your clients promptly and disperse the funds promptly when you can.
In your free time.
Yeah.
Thanks, Myra and Pat. And we wanted to move on to our next topic. This issue has been in the news a lot as well for the last couple of years, and it really came to a forefront last year and arguably has culminated, although many would say it's only been put on hold and this issue is going to come up again. And that is the integration of non-lawyers into the California legal landscape to actually perform work that before was only allowed to be performed by licensed members of the bar. And also the issue of whether non-lawyers can have ownership interests in a law firm. And so we wanted to cover this, including, again, some of the ethical issues related to it and what you are allowed to delegate to non-lawyers, and then your duties and obligations and potential hazards of doing so. Next slide. Just to provide a little context, again, there's been a big push in the last couple of years in California. It's already exists in part in Washington, I think Utah and Arizona, but to allow non-lawyers to perform functions of attorneys here in California. And again, the related issue is allowing non-lawyers or corporations to own law firms or portions of law firms. As a result, there was a task force that was created to deal with this issue. Many out there believe that there was a push by the state bar to get this approved because of those funding issues or shortage of funds that I mentioned before, and also because some of the legal service or corporations out there or corporations that help people take care of legal issues were pushing for it. And last year, there was a call for public opinion on various proposals that were out there. And ultimately, there was a very strong outpouring of comments from members of the bar. I've read as much as 90% of the members of the bar, not surprisingly, were against this type of program. So at this stage, it appears to be dead, although not completely. And again, people think it's going to come up in coming years, at least modified versions of it. For now, though, we're going to talk about some of the ethical requirements for lawyers supervising non-lawyers. Next slide. The reason people were the bar at least was saying they were in favor of this was because they wanted to allow people with less resources, people with less money to have access to the legal system. And so they were supporting this as a way of helping those people get legal support. We just jumped ahead. You can go to the next slide. Again, other states have passed similar programs, and that was a justification for it, but California would have been far and away the biggest state to allow for it. And again, it was intended to improve consumer access to legal services, but many people out there believe it was really just to get funds and to allow corporations to buy into law firms. Next slide. The task force, whoops, one too many. The task force, though, was, I'm going to go back a couple. One more. Whoops, went too many. The task force was created, the task force that was created came up with a proposed, what they called paraprofessional program. And it called for the California Supreme Court being responsible for monitoring the program. It included specifically family law, types of family law cases, criminal cases, employment, and consumer debt issues. Again, the concern would be, though, that it could expand to other areas of the law. And the proposal included non-lawyers' ownership of up to 49% of law firms. And it called for the sharing of fees with non-lawyers. And as Mayra said earlier, fee splitting with non-lawyers is not allowed. Next slide. After calls for public comment on the proposals, though, the lawmakers then amended and passed Assembly Bill 2958 in September of 2022, and that was signed into law by the governor. And with the amendments, it defeated, at least for the time being, the halt to allow corporations to have ownership interests and also to have non-lawyers practicing law, or at least performing certain legal services. There is a statutory ban on what was called the sandbox proposal, which is corporations practicing law, which is called permanent. Although permanent in the eyes of Sacramento is probably a vague term. And it did put a 2-year halt on specially trained non-lawyers, or the paraprofessional program. So for now, the issue is dead, and the members of the bar, I think, did a good job in making sure that it wasn't passed based on a lot of very real concerns. And next slide. So where does that leave us in terms of ethical requirements for lawyers who are supervising non-lawyers? And obviously that happens a lot. People delegate all sorts of work to non-lawyers, including even talking to clients, drafting discovery, pleadings. I will tell you, it comes up a lot, even in mediation, where an issue comes up where one of the parties is relying on discovery responses for either their claim or a defense, and the attorney, frankly, seems quite surprised by it and what was put in the discovery, and the client oftentimes is as well. And so an attorney who does use the services of a paralegal is liable for any harm caused as a result of a paralegal's, or really staff members' negligence or misconduct. And it can lead to professional discipline arising out of the staff's performance of the work. Attorneys are responsible to supervise the work of their employees, including making sure there's compliance with all ethical issues. And you can refer to California Rules of Professional Conduct 5.3 to get more details on that. And it also applies to attorney-client privileges and confidential communications. Again, it's very clear that if you're going to delegate work to non-attorneys within your office, you need to make sure that they're properly trained and properly supervised. And next slide. All of this arises out of BNP Code Section 6125, which explicitly forbids anyone who's not an active member of the state bar from practicing the law. But again, attorneys have an obligation to ensure that staff does not actually engage in the unauthorized practice of law. For example, answering phones and preparing correspondence or even negotiations in an attorney's name with little oversight is technically a violation of these requirements, can expose the attorney to issues with the bar. It's especially dangerous. We've been talking a lot about client trust accounts and client funds, been in the news, to delegate duties to staff involving client trust accounts. And I think with the new CTAPP program, it's even more important that attorneys, especially the ones that are in charge, are involved in management of the firm, keep track of staff, bookkeepers, accountants, whoever, who take care of client trust issues. In addition to the lawyers being in the news. There's also been things in the news about bookkeepers or accountants or others taking client funds. And so all of that, I think the state bar would say the attorney is going to be on the hook for. And then in terms of drafting documents, again, I think it's a fine line. It can be done, but it absolutely has to be done under the supervision and direction of an attorney. You can't just completely delegate it. You certainly can't have non-attorneys sign a pleading or discovery with your name on it, as that would definitely expose you, in my opinion, to problems with the state bar. So with that, any comments, Mayra?
Well, I think there's a big concern with non-lawyers going forward, owning law firms, because many times they may bring, like corporations, and I think we talked about this, Glenn, earlier, they may bring the funding. And with the funding and the money talks. So they may try to exert control over the strategy of the case, or whether the case settles, or whether you try the case. So there's always that risk, along with other corporations that actually fund cases. So that's a big concern that we all have to be aware of. And also, just the fact that a company can come in and have power over a case when they are non-lawyers, when they don't know legal principles, but because of the money they bring to the table, can exert the outcome of the case, is very, very, very dangerous. So those are my 2 cents on that topic.
Yeah, I'll just add it's a good point about the funding companies that are out there, and they're not supposed to exert control over the cases, but it's clear, at least I'm seeing in mediations, that they are out there, and it can impact the handling of the case and ultimately settlements or going to trial. Pat, I'm sorry.
May I say something? And even though it may not be a bad thing, I think it needs to be just regulated. And right now it's not being regulated. That's my understanding.
Pat, did you want to offer some comments?
Yeah, my comment would be basically on the litigation funding front, which is going to become a bigger and bigger issue. And I've dealt with that both as a mediator and as a practicing attorney. As Mayra just pointed out, it's the Wild West. There is no real regulation over what funding companies can do, how much they can charge. They may charge whatever number they want. And it's become a real issue as to how much control they have over the litigation and the settlements. So I think the state bar is going to have to act on that. Now, there is one opinion on that from the standing committee that provides what rules in a general sense apply, which I'll go into in greater detail in my section. I just think suffice it to say that anyone who wants to use litigation funding has to review this issue carefully and understand that there is no regulation over that process of any sort other than basic contract law.
There was a really good segment in 60 Minutes on this issue. So it'd be good to look for it on YouTube and see, because it's real, it's here, it's growing, it's a multi-billion-dollar industry. And but I suspect that because of that there is going to be some regulation, and maybe it won't be a bad thing.
Well, while we're on this subject, I did find that opinion number. It's 2020-204 of the ethical opinions, which covers the ethical obligations of attorneys, including independence of judgment, confidentiality, competence, and conflict issues. So I'd urge anyone who's considering dealing with litigation funding to look at opinion 2020-204.
Great. All right. So with that, I'll turn it over to you, Pat, for our final topic.
All right. Thank you. I'm going to be trying to cover a basic overview of the new rules. If I could have slide 36, Hayward. the main thing to remember about this lecture is I'm going to touch briefly on lots of things, but the important rule is every attorney is responsible for knowing the rules. It's not a defense to any claim of an ethical violation that you didn't know the rules. So therefore, you should leave this conference and take a couple of hours to read through the rules, which are readily available on the State Bar website. The second thing I wanted to notice is there have been 7 opinions from the Bar Standing Committee on Professional Responsibility since the new rules went into effect in November of 2018. And those rules can be found at 2019-197 through 2020-204. And I urge everyone on this conference to at least become generally familiar with those rules. Another comment I wanted to make before we get started is there are some areas there are no rules. For example, there is no rule on the emerging cannabis industry where there's a federal violation of law, but not a state violation of law. There have been some proposed, but none have been passed. So therefore, you can look at opinion 2020 on that clarifies the attorneys may provide advice and assistance to clients with respect to conduct permitted by California's cannabis laws, despite the fact that law, acting under those laws might violate federal law. So anyone who's dealing with the cannabis industry should definitely take a look at opinion 2020-202. So with that brief introduction, I'd like to now cover a day's lecture in half an hour. First, I've tried to focus on rules. I mediate a lot of cases. I've tried to focus on rules that I've gleaned need to be looked at again by a number of attorneys who deal with mediating cases because they show up in various mediated issues. The first is the details of new rules. It's important to remember that any analysis of a rule prior to November 2018 is of questionable validity because all the rules changed then. There were 69 new rules put into effect. 42 of them are new rules and are rather replacements for old rules, and 27 are absolutely new rules. Those rules, together with the modifying opinions provided by the Standing Committee on Professional Responsibility, currently provide the body of law with regard to application of the rules. As I said at the outset, failure to comply with the rules can result in discipline, and it is no defense that you didn't read the rule, didn't know about the rule, didn't understand the rule. So make sure that you look at them. Now to organization, that has changed. Chapter 1 covers the lawyer-client relationship. That's rules 1.1 through 1.18. Rules 2.1 through 2.4.1 cover the duties of an attorney as a counselor. Rule 3.1 to 3.10 cover the duties of an attorney as an advocate. Next slide, please. And next slide, please. And next slide, please. All right, and then the next slide, please. One more. Chapter 4 covers transactions with person other than clients. Chapters 6.1 to 6.5 deal with public service. And then finally, chapter 8 covers maintain the integrity of the profession. All right, the purpose and function of the rules, next slide, please, really comes down to violations of the rules as a basis for discipline. Also, it can set a standard of conduct that some expert will testify defines the standard of care in a particular transaction or undertaking for attorneys, which means the violation of the rules can serve as a basis through expert testimony for a malpractice suit. So knowing the rules is important, not only from a disciplinary standpoint, but also from a a malpractice standpoint. Could I please have the next slide? Terminology in the rules is dictated under Rule 1.0.1, which defines numerous terms in the rules, including belief, informed, consent, knowingly, reasonable, and substantial. So I urge you to take a look at that section. Now let's go to Chapter 1, which talks about the lawyer-client relationship. First, a brief note on competence. Traditionally, the rules talked about just the competence of the attorney handling a particular transaction, and it left it open to some vague notions as to what an attorney was required to do. Particularly in the area of technological knowledge and acuity, the rules didn't cover that, although a Pennsylvania decision that's noted on this slide from their professional responsibility committee did, which noted it's a lawyer's duty to provide competent representation, which includes understanding the benefits of technology and using it. So you need to be technologically competent. Now, a quick comment on competence to relate back to something Mayra said, which is that you can replace competence with engaging another attorney who has competence and understanding a particular area you don't, that you might just dabble in. And so therefore, by affiliating with them in that case, you can comply with that competence requirement. However, as Mayra pointed out, it's important to note that you need to deal with all the fee splitting issues when you undertake that kind of additional professional responsibility. There's also another new rule that I did not put in a slide on, but I think deserves some discussion at this point. And that's that attorneys are now not only bound by competence, but also by diligence. And for that, I'd urge you to look at Rule 1.3, which adds a duty of diligence when representing a client. It provides a lawyer shall not intentionally, recklessly, with gross negligence, or repeatedly fail to act with reasonable diligence in representing a client. Reasonable diligence could mean returning phone calls. It could mean neglecting advising a client of information that a client would reasonably expect to be advised of. It can also provide delay. It can cover a delay in the conduct of counsel, and may even extend so far as to needless interaction with other counsel of a warlike nature that violates the civility concepts of the oath that all of the newer lawyers take whenever they become an attorney. So it's important to look at Rule 1.1 and Rule 1.3 to understand truly the needs of diligence when undertaking representation of a client. Next, if I could have the next slides, please. Communications with clients. As I noted earlier, communication is absolutely critical. Returning phone calls, not delegating that communication to some non-attorney, for example. It's the most important thing that a attorney can do in terms of their relationship with clients. Next slide, please. Confidential information. We all know the fundamental rule that you can't disclose a confidence given to you by a client. That rule has been beefed up in new Chapter 1 under Rule 1.6, which requires that you have a special duty with regard to the confidentiality of your client information and a special duty to protect that information. For example, accidentally leaving your briefcase at Starbucks. Theoretically, that breaches that rule. So attorneys are under a duty to exercise special care in protecting their computer systems and not allowing evasion of client documents or work product. It's a very important series of rules that now, with the improvement in technology, becomes particularly important since you can keep so many client documents on a thumb drive. Next slide, please. Conflicts of interest. That rule has been replaced in the new series of rules under since November 2018. It no longer follows just a checklist approach. Rather, it has a more generalized standard of anything that potentially could limit the client's understanding, knowledge, or rights as the attorney is protecting their interest. It's a very, very, very amorphous standard, which means that the burden is on the attorney to make sure that they fully advise the client of anything that might potentially be a conflict, and reject any assignments that may bring them into conflict. Now, next slide, please. One thing to remember about that before we go to the attorney-client relationship and sexual contact is that it's absolutely critical to remember that discussions at a cocktail party, discussions in a coffee shop, discussion with other attorneys, discussions at a reception, any of those provide an opportunity to betray the client confidence in you protecting their information. Now, with regard to lawyer-client relationship, this is probably the most publicized of all the new rules, which deals with sexual relationships with client. And the bright line rule of thumb is unless there was a pre-existing sexual relationship with a client that pre-existed the formation of the attorney-client relationship, you have a potential problem. And you should read those rules carefully because they are some exceptions, but they're very limited. Could I go to the next slide, please? There are certain exceptions to the conflicts of interest rules. There's a knowing requirement. There is some allowance for ethical screens, but to be effective, there has to be a knowing requirement, and it only is limited to certain cases that you can do that in. I listed here some case authorities that deal with that, and you're welcome to have a copy of these slides, and if you wish to email me or ask me any question, as Mayra noted and Glenn noted, I'd be happy to do that as well. But I urge you to approach any ethical screens with caution, because they not only can cause you to be disqualified from litigation in the future, but one of the penalties for that is you have to give fees back. Another penalty for that is you are potentially responsible for any harm that's caused to the client by your violation of the disclosure of their documentations or interests. So therefore, I would approach ethical screens with real caution. Next slide, please. Very important rule when you're taking depositions, appearing in court. Often if you represent corporations, whatever individual is the face of the corporation in dealing with you, will often say to you something like, I'm glad to have you as my attorney. Well, that's not what is happening. Under Rule 1.13, the organization is your client, and it's up to you as an attorney to clearly point out to any officer, director, or employee that you're representing in a deposition or in court that you're not their attorney. You're the attorney for the corporation. Now, you could potentially get a waiver for that if it's clear, if it's specific, but that creates a risk for you that if things go wrong, the individual may well claim that you violated a professional responsibility to them at that point, putting the interests of your normal client, the organization, over them. So I think this rule of safety in that is to not represent employees of an organization that you're representing separately. Could I have the next slide, please? The next slide deals with the lawyer's rules as a counselor. There are lawyer rules, yes, that apply to lawyers as a third party neutral. One of those is you shouldn't be giving legal advice to one and not the other. Another is rules that apply to lawyers as temporary judges or referees that are much more specific and also arbitrator. The disclosure level, the things you have to do are very specific there. So if you're asked to undertake any assignment of that type, I urge you to review the rules carefully, and particularly Rule 2.4 as it relates to that. Next, moving on to, next slide, please. Moving on to Chapter 3, Candor towards the Tribunal. Glenn and Mayra both alluded to this. This specifically puts down that you must not make any misrepresentation to the court, and that can apply to mediators. It can apply to special masters. You need to read this rule carefully, but the most important thing is do not make misrepresentations in any context, particularly when engaging in factual representations to the court or to the mediator or to the special master or to the temporary judge. Next slide, please. Transactions with persons other than clients. Here is another rule, 4.1, that provides you can't misrepresent to a client who you are or why you are communicating with them. That's an important rule because investigators under your supervision or other attorneys under your supervision or paralegals under your supervision may seek to obtain statements or other information from organizations or persons. You as the supervisor of that cannot condone any misrepresentation as to who they are, why they're talking to the person, and what they're going to use the information for. In fact, I'd underscore that by saying you have an affirmative duty to tell them not to make any misrepresentations to anyone that they're contacting, both under Rule 4.1 and under Business and Professions Codes 6106. Next slide, please. Next one is transactions with persons other than clients. That is, talking to a misrepresented person. Rule 4.3 sets forth very clearly what you must disclose to that other person and whether you can talk to them at all. I think this is a rule that is often honored in the breach by attorneys, and we need to revisit how closely and succinctly we look at this rule, because basically you need to know this rule exists and you cannot seek information that would be privileged if they were in communication with their attorney. Don't forget, friend requests on Facebook can count as a misrepresentation. So frankly, you should be very cautious in any friend requests you accept. And from the judicial side, it's important because judges have been disqualified for accepting friend requests from attorneys or parties. So be very cautious in how you approach that. Could I have the next, please? Next slide. Glenn talked about the rules for law firms and managerial versus supervisory employees. That is a two-way street. It applies both to the supervisor and to the supervised. As I mentioned earlier, supervised attorneys have a duty to exercise independent judgment. So there has to be a basis upon which they can testify under oath someday that there was an arguable question and the supervisor's resolution of that question was reasonable. Also, it's important to remember a managing or supervising attorney can be vicariously responsible for the lawyer's violation if the lawyer orders or ratifies the conduct. That rule extends beyond that, as we saw earlier, to persons who are not attorneys that you supervise, but rather are lay people, paralegals, or any other person who doesn't have a license to practice law. So remember, as a supervisor, you can be responsible, vicariously responsible for a lawyer or non-attorney's violation. As a supervised attorney, you can be responsible for not ensuring that whatever instruction you were given appeared arguably reasonable, and you exercised your independent judgment in deciding to follow it. Next slide, please. Going to law firms and associations, as I noted, look at Rule 5.2 and 5.3 with regard to the rules of subordinate lawyers and regarding non-lawyer assistants. Next, moving to Chapter 6, next slide, please. Rule on membership in legal service organization. They've cut the bar has cut attorneys somewhat a break in encouraging volunteer service under circumstances where the organization that you're serving on a board of may in fact be in opposition to a client. But I urge you to read that rule carefully, because Rule 6.3 is very, very specific in terms of the steps that you must take in order to avoid exposing yourself or your organization to a bigger conflict of interest problem. I also urge you to look at Business and Profession Code 6068. Rule 6.5 deals with limited legal service programs. If you're involved in organizations that deal in limited legal services, and there are various of those in Los Angeles County, for example, LAFLA would be one of those. I urge you to read Rule 6.5 in depth before you undertake any of those representations. Information about legal services. This deals with puffery. A new rule, 7.1, provides that you cannot make misleading or false statements about you or your services. This would particularly apply to representing that you don't, representing that you have an expertise that you don't, or representing that your background or experience is different than what you're stating it to be. All of these are false, misleading communications under Rule 7.1. And I know we've recently seen in the rules that there may not be a special rule for legislators, but that situation will have to play out. But that's an example of the false or misleading communications that could get a lawyer disbarred. Next slide, please. Going on to Chapter 8, which is maintaining the integrity of the profession under the general heading of misconduct. I urge you to look at Rule 8.4. That defines specific instances of misconduct. Some of those are knowingly violating the rules or assisting another in doing so, committing criminal acts, engaging in conduct prejudicial to the administration of justice, engaging in dishonesty, fraud, or intentional misrepresentation, state or imply an ability to improperly influence a government agency or official, or assist or induce a judge to violate the code of judicial ethics or code of conduct of law. Those are all bright line rules that, if violated, subject you to discipline for 8.4 misconduct. Rule 8.4.1 is a new rule which deals with prohibited discrimination, harassment, and retaliation. I urge you to read that rule carefully. It removes the requirement that there be a prior adjudication that the conduct was unlawful before a proceeding can be commenced under this section. And it imposes a self-reporting obligation to a relevant state, federal agency on a lawyer who receives a notice of disciplinary charges for violating this rule. Now, if you compare this to the earlier rules we discussed about the rules requiring a subordinate attorney to act reasonably on instructions that have a reasonable basis and to exercise independent judgment, you have to read the four corners of these rules as a whole. And in theory, that earlier rule could apply to circumstances under this new rule. And it's important to remember that it also added retaliation, and it also established, as I noted earlier, a self-reporting requirement. Now, I'd like to spend a moment, if I could have the next slide, on some additional references. I'd urge you to look at Business and Profession Code 6068, which defines the statutory duties of attorneys, because that is a rule that has to be read into the rules of professional responsibility. And I particularly urge you to look at, for example, Rules 1.6a and 3.3b, and read those in light of Business and Profession Code Section 6068. And finally, I'd like to spend a couple of minutes on what I alluded to earlier, which is the opinions that come forward from the State Bar's Committee on Professional Conduct. First, I mentioned earlier opinion 2020-204, which deals with ethical obligations of attorneys where funding is made a part of the case. That's going to be a hot area, and every attorney who potentially is involved in litigation funding must read that opinion. Second is Rule 20-203 that discusses the ethical obligations of lawyers who suffer data breaches or electronically stored client information is lost. That's a special rule for that and needs to be read in conjunction with the rule I mentioned earlier with regard to not disclosing client confidential information, the so-called leave your briefcase at Starbucks discussion. The next rule I'd like to mention is Rule 2020-201, which deals with ethical challenges which arise when an attorney departs from his or her law firm, and it stresses each client's interests in the lawyer, having to do with the lawyer and the law firm. That comes back to the questions of lawyers who depart firms and get into litigation with the firm over cases and fees. I'd next like to point out Rule 2019-200, which discusses issues of what an attorney must do when they suspect that a witness in a civil trial has testified falsely. What are the attorney's duties when an attorney knows the witness has committed perjury? And what an attorney must do when they first learn of the perjury after a witness had testified. For those of you who are trial lawyers, it's important to know that opinion. And finally, what are the rules that apply when an attorney consults with outside counsel? You'll recall earlier I talked about how consulting with outside counsel can help with the competence and diligent requirements under the state bar rules. The question is, what must an attorney do when they bring in that other firm? And the rule there falls back on the general rule of confidence and diligence, in that you have to evaluate what the other attorney is doing. And even though they're the expert, in a way, they become like a supervisor, and you have to judge using your independent judgment whether they acted reasonably. Where I've seen that issue is in defending law firms as an attorney, where anyone who touched a case may potentially be argued to have participated in a conduct below a standard of care. So that's an important safety tip with regard to that rule. Additional references, there's the ethics hotline, which you can contact at the phone number that's listed. If you have an ethical question, you can get a request to the State Bar website. Could we go back one slide, please, Hayward? And now go forward again, if you would, and then to slide 61. Correct, to slide 61.
I show 61, Pat, for additional references.
You go to the next slide, please. All right, cases on civility. I had the honor of being the president of the state bar when the civility undertaking was added to the attorney oath and participated in that process. Since that time, civility has become an extremely important issue. There's a committee that's been formed on civility in the state bar on which I sit, and it is looking into having all bar associations adopt rules of civility in the handling of cases. I've cited here 3 cases: LaSalle versus Vogel, Martinez versus O'Hara, and Brigante versus Chow, which all dealt with situations where attorneys were accused of incivility and set forth some guidelines with regard to conduct that would be declared to be uncivil. And in fact, in one case required a judge to report that conduct to the state bar. So civility is here, it's here to last, and it's important that every attorney who reads the rules understands that civility is read into those rules. Last slide, please, to 62. I'd like to thank each and every one of you. You can reach me at ADR Services. My email address is shown here through my case manager and individually, and I'd be happy to answer any questions that any of you might have. Now there are a few moments left, and I'd like to turn the floor over to my other 2 presenters, Glenn Barger and Mayra Fornos, first to congratulate them on an excellent presentation and to ask them if they have any particular comments they would like to add to this, shall I say, speedy introduction to the rules of professional conduct.
Well, Pat, that was just magnificent what you covered. You are truly legendary. And from what you said, I kept going back to the duty of candor, because it seems like many of the rules stem from this very important rule, where in mediations, I have seen many times attorneys come in and they know, they present what either a client or a witness has mentioned to them, and they know it's not true, but they nevertheless present it. And naively, I don't want to say in a horrible way, in you know, their client is telling them this, their witness is telling them this, but they inherently know it's not true. And so what happens is that there's a line in the sand that can be crossed. And when that happens, it's hard to go back or to be trustworthy. All right. And so it's important to keep check on what you're saying, that just because they told you this, that it doesn't mean you have to present your case with that information if you know that it's a material fact and that it's not true. And so many times what I see is that they do this because it helps their case. And so in the end, the truth always comes out, always, and it hurts them. So keep that in mind, ladies and gentlemen. But what I saw is that many of the things you cover come back to just the integrity, the honesty, the ethics of protecting the justice system and doing things the right way. So thank you for that. I learned a lot from you and from Glenn today.
Glenn, do you have any additional comments?
Muted there. Just a couple things that I think are interesting for people to monitor. On that task force on civility, they actually called for public comment this week on 3 specific changes that I'm aware of. And the deadline to provide comment is January 30th of this year, obviously. One of the changes is Rule 1.2 being modified to state that a lawyer has authority to conduct themselves with civility, even if the client directs otherwise, so long as not to prejudice their client. The second proposed change is a standalone Rule 8.4, which provides guidance that certain uncivil conduct, and uncivil conduct is defined or defines incivility as significantly unprofessional conduct that is abusive or harassing. And within the new rule point 8.4, there's some comments to provide further examples of incivility, which will be worth looking at. And then the also a new standalone rule 8.4.2, which again states the proposed rule shall not engage in incivility, or attorneys shall not engage in incivility. Clearly, there's a focus on this, as you just said, Pat. And I do find it interesting. You mentioned the requirement for new state bar admittees beginning, I think, in 2014 to confirm that they're going to practice with civility. I'm not sure what that says about people's thoughts on attorneys in general. I was driving around town last weekend and I felt like everyone on the road should have to sign an incivility statement or statement that they won't be or they'll act civilly when they're driving around LA. But clearly there's a conception about attorneys that we need to act with civility. I think in part it comes from judges, but overall, I'll say that attorneys I deal with on a day in and day out basis are civil with each other. And most of, I think almost all of the top attorneys out there, including the most aggressive of aggressive that I've ever spoken to, agree that it's in their best interest and their client's best interest to be civil. Doesn't mean that you can't be aggressive or advocate for your client, but you can still remain civil in doing so. And so I actually think most attorneys do follow it, but clearly there's a focus on it. And I think attorneys probably want to monitor these issues. And lastly, there's also another issue in the assembly, I believe. There's been a proposal that attorneys are going to be required to report misconduct of other attorneys. California is apparently, I read this in Arash Ramapour's article he wrote, I think last week in the Daily Journal. California is the only state that does not currently have that rule in place. And some people believe it's don't snitch on your fellow attorneys. Others believe it's going to create a whole host of issues among attorneys if you're required to report it. But it's something that I think all attorneys should monitor because it may impact the professional rules of conduct going forward in the next year.
Glenn, I think you've raised a couple of important issues. As I mentioned earlier, there's a committee on civility formed under Justice Dan Curry. I'm a member of that committee, and a number of recommendations have been made. One of those recommendations is to require that on an annual basis, attorneys have to sign off on the 2014 addition to the oath that we added at that time. And so therefore, that's in the wind that may become a rule that attorneys have to sign off on that oath to conduct themselves with integrity in all ways each year. With regard to the so-called snitch rule, you're correct. California is the only jurisdiction that doesn't have that. It's yet to be seen whether that's going to pass and how that would apply if it does pass. But you're correct, that's in the wind. It's something people should keep their eye on.
All right, so thank you, speakers. I do have one question because I wanted to ask this because I know that for the last 2 hours, that's a lot of information to take. We have one question that I'd like to ask you, Mayra. We have inquiring minds as to which team signed your hockey stick.
Oh, it was the Kings.
Okay.
when they won the championship here. And I live in the South Bay, so the South Bay hosts all sorts of events for the Kings. Many of them live here. So.
All right, wonderful. Well, thank you, Glenn, Mayra, and Pat for that very informative presentation.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront. Woman-owned and operated, from the start. There is someone for every situation. We are ADR Services, Inc.,